One, 3 quick stories, including the terms, the words, the debate at the Supreme Court around abortion. And it turns out a man can say he's a woman and blow female swimmers out of the water. Plus, here comes COVID tyranny. 2, a deep dive conversation on everything you need to know about COVID, and specifically Omicron and vaccine efficacy with Dr. Mark Siegel. And 3, Will's weekly quarterback depth chart and my betting picks of the week. It's the Will Cain podcast on Fox News Podcast. Welcome to the weekend, one day early. Welcome to Friday. Let's get a jump start on the weekend because I have a jam-packed episode for you today. I think you're going to want to hang in from beginning to end. Stick around. At the end of this podcast, we'll dive into the world of sports. I'll give you my picks of the week. I'll do better. I'm on a bit of a skid. Stick around because, at worst, you can laugh at my picks, plus my weekly quarterback depth chart. And we have a long, I think really fascinating interview with Dr. Mark Siegel of NYU Langone Health about every aspect, updating us on the freak out, the panic, and the hysteria of the Omicron variant of COVID. I'll press him. I'll ask him, do the vaccines work? And do the vaccines have any bad side effects that no one is willing to discuss? But we start with some quick hits. We start with 3 stories that I think deserve your attention. Story number 1. A, the big debate, the big issue of the week is whether or not the United States Supreme Court will, in essence, overturn Roe v. Wade. The Supreme Court heard oral arguments this week on Mississippi's ban on abortions after 15 weeks. Here's what I think is incredibly valuable about the abortion debate making its way to the Supreme Court. We're forced to have the conversation on its merits. Here's what I mean. First of all, it's not healthy for the society to be debating abortion at the Supreme Court. I'm going to explain why in just one moment. But this is the type of both scientific and moral question that should not be left up to 9 unelected seers. I say S-E-E-R-S, seers, like the oracles at the top of Mount Delphi in Greek mythology, the people who we entrust to tell us our future. Make no mistake, I have great respect for some, highlight, underline, italicize, some of the justices of the Supreme Court. But because they, some, are good at logic and reason, does not give them special insight into science, or more importantly, morality. Such a divisive issue as to whether or not we should be able to legally kill the unborn is a question first left up to the people and second left up to God. Still, it's clarifying for these debates to make their way to the Supreme Court because you can get past the nonsense, both on cable news and in our personal lives, where the debate is reduced into 2 people talking past each other. One party is talking about the life of the unborn, and the other is talking about the right of women to choose. The key is the right to choose what? Justice Clarence Thomas showed great interest in that question at oral arguments. He kept asking the attorneys for the groups hoping to knock down the Mississippi abortion law, what right specifically is at stake? What right specifically is protected in the Constitution? You take that for granted, and it's always good to go back to the basics of our debate, the basics of the question at hand. Thomas, in particular, is good at that because you can build a temple, a house of cards, an argument made of popsicle sticks on a foundation of sand. Thomas is one, with the late, great Justice Scalia, to always revisit the foundation. What is the basis of this argument? What is the right that we are debating? He asked, is it a right to abortion? Is it a right to privacy? What right are we preserving in the Constitution? Now here, and I don't want to go too far into legal analysis because it's eye-glazing white noise, but it's also important. Here is the crux, the foundational argument. In 1970s, I believe it was in 1972, Roe v. Wade was decided. Now, the justices of the Supreme Court, in creating a right to abortion, a constitutionally protected right to abortion, had to find justification inside the Constitution, because you know as well as I do that Thomas Jefferson, Alexander Hamilton, and the Founding Fathers didn't write in Article 3, the government shall not infringe upon a woman's right to destroy an unborn fetus. So what the judges did is they manufactured, and I think most people would agree, even those on the quote-unquote right and left, although it doesn't neatly break down when it comes to constitutional law, but most would agree on the right and the left, that they manufactured a right to privacy. And where did they find that? They found it specifically in the 14th Amendment, which preserves the concept of due process. But that's also not a traditional understanding of due process. Again, you probably have a working understanding of what is due process. That you won't be thrown in jail without your ability to see a judge. There won't be a presumption of guilt, a whole host of things that we have preserved about what the government can do to you or cannot do to you without allowing yourself to be heard inside the legal system. So what they did, and what they have, the court over time, is develop something called substantive due process. Now, I know, here we go, deep into the realm of eye-glazing white noise when it comes to legal analysis, but the long and short of it is, substantive due process is whatever you want it to be. It's the white space between words. It's literally the vacuum in which they can pour anything they want. They literally mean it's implied. It's implied within the right to due process, in essence, that you have a right to an abortion. I know that's an odd thing to conclude. It's an odd leap to take. They jump from a traditional definition of due process to the concept of a vacuum, a void of substantive due process, in which you can pour all kinds of rights you want to manufacture, including the right to privacy. And then from there, the right to privacy implies the government can't intrude upon your right to an abortion. When pressed by Thomas, the attorneys for those that want to knock down the law of Mississippi said it's all of the above, meaning all rights the above. Of course they would say that, because it has to stay in the realm of white space. If it's ever enumerated, if it's ever outlined, if it's ever given language, then it can be rebutted. It's a loose concept of liberty. But here's what I think we should take away. Here's what we should look for, because the Supreme Court will decide this case in the spring. They've now heard oral arguments. And the question for the nation is, will they knock down Roe v. Wade and Roe v. Wade's sequel, Casey versus Planned Parenthood? Roe set up the trimester system, and Casey advanced us to the concept of viability. There are two concepts, setting aside substantive due process. There are two concepts that you need to pay attention to understand what the Supreme Court may decide. One is viability, and the other is stare decisis. So let's deal first with viability. Viability is the idea that you can terminate a pregnancy up until the moment of viability. That is, that a fetus can live on its own outside the mother's body. Now, what is viability? I mean, the easy cop-out answer is to say 15 weeks, 20 weeks, 25 weeks, 30 weeks. That doesn't really have any scientific backing. It also isn't foolproof. Fetuses develop at individual paces. Not great variance, but still variance. But you throw down a hard line and you could theoretically be, in one instance, killing a viable human being, and in another instance, legally aborting something you do not consider to have rights, a fetus. So what is viability? What does that mean? And the answer is, who knows? No one knows what viability means. Science doesn't know, because science has changed through time. What was viable in the 1970s, or was not viable in the 1970s, is viable in 2021. As medical advancements proceed, we have the ability to nurture and incubate a fetus much earlier in the cycle of life. Roe broke it down into trimesters. You can have abortion in the first trimester. I can't remember the first standards of Roe. You can't have it in the third trimester. That was obviously unworkable and unscientific over time, so they evolved. But viability is a scientifically moving standards as our technology and medical capability improves.
For the full podcast, go to foxnewspodcast.com.